And joining me now to talk more about the Bruno case is legal analyst Paul DerOhanessian. Thank you very much, Paul, for being here. This is a complicated story, and really, it's really quite something. 7 years.
It really is to see a case like this still going on after many years. And the acts that we're talking about today go back to 2004, and the original indictment went back even before that.
So let's start with something that I don't understand. Theft of honest services. They're actually charging him yet again under the same law, but I thought that the U.S. Supreme Court had limited that law.
Honest services is a crime that can be committed in a variety of ways. Just like murder can be committed in a variety of ways. You can intentionally kill someone, that's murder. You can do it in the course of committing a felony. Well, honest services had one section which involved the concealment of information. That section was deemed too broad and unconstitutional. But the Supreme Court, and this is the issue in the Health Care Act, can you parse out the statute and say something is legal? What they said is there's a bribery and kickback component of honest services. That theory is legal. That's why he can still be prosecuted under the honest services law. A portion of it is still legal.
So they didn't, the prosecutors didn't make that argument in the initial case, right? So in other words, they are now trying him under the same fact pattern, yet with something that they completely avoided the first time around.
That's right. And their position would be that they had a valid theory. It was legal at the time. We didn't need to use the bribery kickback theory. And this is the issue that came up at trial. And they were very clear at the appellate argument in New York City. It's not that we said there isn't a quid pro quo. We're not saying there isn't a kickback. We're saying that's not the theory that we're using in this case. And that's why we should be allowed to try him again using this theory as long as there's sufficient proof and facts that were presented at trial to justify that theory.
But when it comes to the question of strength of the case, logic, and I know, and I'm not a lawyer, but logic seems to indicate that you put your strongest case first. So if in fact they didn't make that bribery kickback argument the first time around, what's to say that now it's a good idea and strong enough to charge him again?
Well, let me talk about the assumption you're making, and that is that it wasn't the strongest theory. There were 8 different charges. They had different components to them. Some had a bribery kickback component to them.
Right.
And I think what the prosecutors tried to do is to simplify their case, which was very complicated, and I think that was a problem, having 8 different fact patterns covering so many years, to have one theory that unified them all. And that one theory was the concealment of critical information, the theory that's now unconstitutional. So I think that's why they did it, and they felt that would be the strongest approach to try to bring in all these counts. They may have been wrong in that. That may have been maybe too complicated. So that doesn't necessarily mean that they didn't have, in their opinion, a strong theory or fact pattern to support bribery and kickback on these 2 counts that they're dealing with now.
So their approach was flawed, as it turns out.
Well, that's in hindsight. And again, their position is it was valid at the time to do that, and this was a simpler way to present 8 very different fact patterns.
Okay, explain why this is not double jeopardy.
Well, to have double jeopardy, you have to have been tried and prosecuted for a crime. And what the court is saying is there was no crime to be prosecuted for using the theory that they did. He was never prosecuted for that crime. Therefore, he's not being prosecuted on that same theory. It's a different theory that he's being prosecuted for now. That's why it's not double jeopardy.
Well, it makes sense to you and it makes sense to me. But I guess this is sort of ancillary to what's actually going to happen in the courtroom. But in the court of public opinion, people see an 83-year-old guy who says the government's out to get me. And the more you look at it, when you don't understand the legal theory of double jeopardy, you kind of wonder if people, you're making him into a sympathetic character.
You know, this happens all the time. It happens every day. The theories that were used by the appellate court to justify the re-indictment of Senator Bruno are the same theories that many individuals get retried on every day, and we just don't hear about it. What you're seeing now is kind of a peephole into how the legal system operates for everybody. Just like when we saw Senator Ted Stevens prosecuted, we got an insight into how there can be problems with the disclosure of exculpatory information. Those issues come up every day, but sometimes it's only in these most visible cases involving prominent people that we get to see how the system operates.
So, but does a person of prominence like Joe Bruno have an argument to make to say, you're targeting me because of the position, and P.S. that he used to have. Now he says, or his attorneys say, he's a private citizen, leave the guy alone, right? He's no longer the man that he was.
Individuals, even those who are not prominent, feel they're being targeted. You hear that all the time from clients sometimes. Look, other people were doing this. doesn't the prosecution have anything else better to do?
Right.
But that is not a legal defense at all. It is something to certainly argue and to gain sympathy, and the reality is that prosecutors have a tremendous discretion. And when they decide who they're going to prosecute, shouldn't they be more concerned about someone who may have a greater position in the system capable of doing more harm? That is their discretion they have. That would be the argument that they make. And yes, it's true also they may overlook other people doing similar conduct because they feel that in this situation it merits greater scrutiny because of the position. And that's what politicians sometimes I think have a tough time believing, is that there's a downside to being prominent. There's a downside to being a prominent individual. John Edwards is being prosecuted in many ways because he was a vice presidential candidate. Yeah. It's a very novel theory. It's very difficult, but he too could say the same thing, and in fact has said the same thing.
So, and also is the idea, and we can't get into the prosecutors' heads, of course, but is the idea in general behind the going after of people who are prominent that you might send a message to other people? For example, we see a lot of corruption cases being made by U.S. Attorney Preet Bharara for the Southern District, and he always talks about the idea being, we're going to go after this until you guys stop doing bad things, right? Is that the thought?
I think that's part of the thought. I think the thinking is that political corruption is important. We want to show that people aren't being treated differently because they are elected officials, because they do hold positions of prominence, to show that there is equality. And as I said, we see these types of prosecutions in other individuals whose cases we don't hear about, the same theories being used to charge them again. I think that is the argument that would be made. And remember, there have been many other legislators who have been prosecuted. It's not just Senator Bruno.
Sure.
We've seen assemblymen convicted and sent to jail. I think the belief that it changes the system, though, is wishful thinking on prosecutors. And if you look at Illinois, for example, how many governors of Illinois have been prosecuted for political corruption over and over again? Does the message get through?
Two?
Yes,
three.
It's three.
It's three.
Three governors, I mean, almost in a row. Does it really have an impact? I don't think that, I think the idea that it will have a deterrent effect, is wishful thinking. I think there's still reasons to bring prosecutions, but we can see that politicians haven't changed their behavior in Illinois or New York State because of prosecutions and convictions.
It's also the same cast of characters here, right? It's the same people who spoke to the grand jury. It's a different grand jury. I mean, grand juries are impaneled all the time, but it's the same people who say the same stuff. It's the same story. The trial essentially will be the same information. Do you expect new information to come out in this trial?
I don't expect significant new information. What I expect, in fact, is a winnowing of the case, much less proof, much less, because we don't have 8 counts anymore. Now, that may be an advantage to the defense. It may be an advantage to the prosecution. We'll have to wait and see how that plays out, having a much smaller, simpler case. There's really one main character in this, Abruzzese and his activities.
Yeah.
So in some ways, it'll be simpler to follow. On the other hand, the prosecution may not have access to the mountain of other bad acts, but again, as I suggested, that may have been more difficult to follow all those different acts and 8 counts back in the original trial.
Yeah, you and I spoke just before the camera started rolling, and I mentioned there was a pension piece of this that I had been surprised that allegedly the former senator had encouraged labor unions to invest their pension funds with a certain entity, a Connecticut entity that he had connection to, and that he did not disclose that he stood to personally gain if they did so. I was surprised that that never went anywhere. Do you imagine that that will this time become more prominent, if you will?
Well, he was acquitted of that. The question is, and this will be a question really that's up to the judge, is whether or not any of these other acts have any relevance. And the defense is going to have a strong argument because he was acquitted on it that it shouldn't be.
Right.
But I think what defendants have a hard time understanding is that when you're acquitted of things, sometimes the evidence still comes in. And as we saw in Senator Bruno's sentencing, the prosecution was able to argue that acts for which he was acquitted could be considered by the court in his sentence. And I think that's a really shocking thing to individuals to hear, whether they're the public or defendants, that you can be acquitted and still be punished for what you're acquitted of.
Here's something, and some people, many people I should say, when they talk about this, suggest, oh, he won't do any time, he's too old, it's going to drag out, he'll appeal. And the longer it drags out, the more expensive it is. And that's actually a key point that sometimes gets overlooked here. This bill is probably very high for his legal defense at this point. He wants the state to cover it.
Oh, yeah. I think that's something we shouldn't overlook. Is one of the reasons a lot of these cases you'd expect could be resolved. Remember, the sentence here was 2 years. There's room for perhaps a plea to a misdemeanor, a plea to a felony, no jail time. But what happens is any plea would negate any ability and right to collect his defense fees from the state. The Attorney General has indicated already that as long as this prosecution is pending, he was not going to pay Senator Bruno's legal bills because he had been convicted before, and the appeals decision says there's a valid line of evidence here where he could be convicted again. So that's why you won't see a plea in this case. The legal fees that the senator is seeking to get paid by the taxpayers is in the millions of dollars. So you can see that this prosecution has another component, a non-criminal component, that's worth millions of dollars.
Well, Paul, I want to thank you very much for being here to make sense of this all for us, because it really is fascinating. And of course, in the Capital District, we've been following it for many years. I'm sure we'll be talking to you again.